Is assault and battery considered as two different crimes in Florida? Attorney Josh Faett explains that. Florida defines assault and battery as two different crimes. A lot of times in the common speech, assault and battery are equated as the same thing. However, an assault in Florida is a misdemeanor and is defined as the intentional or unlawful threat against another person. For example, if someone were to say, "I'm going to hit you and I'm going to hurt you," and had the apparent ability to carry out that threat, then that would be considered an assault. This means that if you were to call someone on the phone or yell a threat to someone from a distance, then it may not be considered an assault because you wouldn't have the actual ability to carry out that threat. Ultimately, if someone does or says something that causes someone else to feel a genuine and reasonable fear that violence or harm is imminent, then it may be considered an assault. It doesn't have to be an actual threat. However, if the person who is hearing the assault or the threat believes it to be so, then it doesn't have to be something verbal. It can be a physical assault, running at someone, or holding your fist up and moving it towards them. A battery, on the other hand, is defined as an intentional touching or striking of another person, or unintentionally causing bodily harm to someone. So, a battery requires some physical contact. A battery does not have to be something violent. If you're intentionally going to reach out and touch someone as lightly as you can on the shoulder and they did not give you permission to do so, that can technically be a battery. So that is the difference between an assault and a battery. Contact attorney Josh Faett in Florida for your complimentary strategy session today. The Faett Firm provides experienced criminal defense representation to individuals facing criminal charges.